Okay, we're back. This is part 3 of 8, and this is going to include part of the second section of this article, if you will, this document, Introduction to General Federalism. And the second part is why new ideas are needed. So in part 2, we were going through the list of reasons why general federalists would argue that new ideas are needed. And we had finished with reason number 5, and we're about to go to 6. And so now we're going to go to 6. We still won't get through this section. There'll be another video to finish this section. So we'll go through the list and get as far as we can here, and then we'll see after that we'll finish that. So the sixth reason why a general federalist would argue that new ideas are needed and that we can't just rely on old ideas that we repackage or rehash is that the future of humanity depends on a viable global government. And in a system based on constituent participation in governance, such as through special interest, not just delegation of power, the system quickly becomes dominated by a pattern of moral hazards, which are in turn used to suborn rule of law and violate civil liberties with abandon. So for that reason, we need a new idea that avoids these moral hazards, has some way, some structural way of avoiding or minimizing or reducing these moral hazards. And this happens because the public pressure and scrutiny on public officials is so high when applied by well-financed special interests. Blame must be displaced and spread out over several individuals in order to protect themselves. An excellent example of this deflection of accountability was shown in our discussion of how politicians draft overly broad laws with overly broad definitions to wash their hands clean of any wrongdoing and talk out of both sides of their mouths. On the one hand, bowing to faction, and on the other to their constituency. And another point to add to that, too, and about that discussion is, the attorneys in the crowd might say, well, but this is what equity in law is for, because the argument would go, and this is very much a normative argument, it would go, that, hey, a legislature can't write a law to apply to every single circumstance. So there has to be some generality in the definitions and in the punishments meted out. And that's certainly true. But that argument misses the point. And the point is that equity in law and rule of law should be balanced. And the only reason we have courts is, or that we should say, the utility of a court system is valid and real only to the extent that the legislature cannot write laws any more specific than what they are. So it's really, the question is really, what's the feasible limit of the specificity, not do you just write one law that's so broad, and if you take that argument to its ultimate extreme, it would be, well, we could just write one law and the courts could determine everything else. It would just be one vague definition and one vague set of consequences for violating it, and the courts could just interpret everything. So obviously that can't be an adequate argument by itself, and it's not, because, as I said, the utility of the courts and the reason why we have them is only because there's a feasible limit to how specific the laws can be. Under a system that follows rule of law, that system should write laws that, to the extent feasible, are as specific as possible. And only where it's infeasible do they introduce any degree of generality in definitions or consequences. And what we're seeing is like with things like the Patriot Act and the other things mentioned, is that this is much, much more general than what could have feasibly been written. It would have been very easy to write a law much more targeted and much more defined than that. It's absurd. And by making it so general, that's what we mean by a moral hazard. It's creating a moral hazard for the judges, because now they're given too much territory over which to examine the laws, and it suborns equity in law. It actually undermines the process of equity in law. So there's a balance between those two things. It's not all or nothing. It's not black and white. And what we're seeing is, and like I said, the easiest way to test that and to know whether or not something is a law is too general, either in definition or in terms of consequences for violating it, is to simply ask, could a more specific law feasibly have been written that would have narrowed these definitions a little bit, narrowed the ranges of punishments a little bit? And if the answer is yes, then it is suborning rule of law. It's undermining rule of law, period, by definition. So, and that's a normative argument. I could use a normative argument to say that. So anyway, that's what I just wanted to add to part 2 that I hadn't mentioned there. So one can do this generally by creating moral hazards, and I'm following up on this deflection of accountability thing. So one can deflect accountability by creating moral hazards, which are inherently deniable, and those that fall prey to the hazard can justify it based on the false choice they claim it presented. In this way, they can do the corrupt bidding of faction by appealing to special interests and lobbying while simultaneously averring to their constituency that they have not. It's a massive scam. We shall see throughout this introduction, that in virtually all neoliberal Western democracies, this is exactly what has happened, and that a full understanding of how they work is simply not possible without taking the ubiquity of moral hazards in these systems into account. Muammar Gaddafi, of all people, is one of the few in the public domain who also identified the fraud of parliamentary democracy, as we have here. However, his further treatment and understanding of the problem, as outlined in his so-called Green Book, we believe was incomplete and replete with factual and logical errors. So, and probably more importantly, it really wasn't entirely original. We don't think those ideas are a good answer either. And it's kind of ironic that you have to go to some of the worst enemies of a particular value system that you subscribe to in order to find people that can see through this and see the weaknesses in that system. So that's kind of ironic and interesting. But anyway, therefore, a global scheme of governance absolutely must solve the issue of moral hazards by the introduction of considered profound new ideas. Number 7, seventh reason why new ideas are needed. The sheer complexity of global governance is overwhelming. There are 2 key areas where this needs some original work, as we have seen no proposal that would actually work. First, the fundamental law, or the Constitution, that frames global governance in rule of law must be as simple as possible, while still being sophisticated and complex enough to address the problem at hand. While it could be argued that the Constitution we've come up with so far is large, about twice the size of the U.S. Constitution, which is pretty Spartan, for a global scheme, we think it's pretty Spartan, especially when compared to the War and Peace of constitutions, such as the Maastricht Treaty, which doesn't even clear the bar of a constitution. Second, B, the basic administration of such a government could easily get unwieldy and impractical. We are already seeing in the United States that exacerbating technological deregulation is the sheer complexity of managing a social contract in an area where such a large economy, so many people, so many laws, and so many interests outside the country apply. Our proposal is to empower, quote, lawful delegates through a federation civil corps that is constitutionally defined. Acting as delegates of the respective houses, members of the civil corps would be responsible for handling the day-to-day issues of governance throughout a federation, however large it may be. In this way, a merit-based system whose authority and power reach is constitutionally limited and framed can be employed and scaled up or down to whatever extent global governance may then require. Key to this provision has been the constitutional mandate for its existence, which ensures that unelected bureaucrats, basically the same kinds of people we think of when we think of disaggregated states, which we'll talk more about, operate under rule of law and are accountable to the people. In this sense, the Corps is something more than just a bureaucracy, but is in some sense like a department of the military or some kind of paramilitary, law enforcement, something like that, where the employment and promotion is pegged to merit and the discipline is very high. Maybe not quite like a military, but certainly an organization where the discipline is very high. The 8th reason, experts who have studied the matter in detail have, not surprisingly, concluded that an open and free election involving what would potentially be the entire population of the world would be logistically infeasible and essentially impossible to perform. The reasons for this are many, But recalling that we seek a general solution to the issue of global governance means that we have to consider the fact that some localities will have relatively low levels of corruption and fraud in elections, such as countries that have a long tradition of open and free elections, while others would likely have relatively high levels of corruption and fraud in elections, such as countries that are new to the process or simply have a history of difficult elections. Therefore, we must find a general solution to this problem and to the problem of margins of error. In any election involving such large numbers of voters, the margin of error, even if all elections were performed with no fraud or corruption at all, would be quite large. It is impossible to hold an election that is completely error-free, and the larger the voter base, the greater that error. This kind of uncertainty is bad enough at the national level and can cause constitutional crises at that level. Recall the Bush-Gore presidential election in the United States, where the margin of error was precisely the problem. But it would be disastrous in a global governance scheme and simply cannot be allowed to happen. At a global level, constitutional crises must be avoided at all costs. So what solution can we offer? And here's some more prefiguring we're going to do here. Much more will be discussed about this later. The determination of succession in office must be highly deterministic in the sense that validation of the lawful successor is as simple, clear, and irrefutable as possible. The succession of power also constitutes an act of delegating power, whether implicit or explicit. Therefore, it must have some means for public participation that is inherently representative, at least to the degree feasibility allows. If this cannot be fully realized due to the practical realities mentioned, then a means of revocation of that power by the public must be equally deterministic as a fallback to ensure representative governance. So where this led the discussion originally was kind of looking at sort of the parameters available in terms of ideas. One extreme solution that was considered to inject some certainty into this process was to look back to the old methods of heredity, which are obviously not well accepted in this day and age. But just as a way to provide perspective to see what you might be able to do in a representative system that's short of just a simple heredity-based type solution. And what they've come up with, and it's still a open area of discussion. But basically, the idea now is that if you can't hold a global election all at the same time, then you can split it up. So the idea is to split it up in such a way that you can have elections that constitute direct elections for the Senate and indirect elections for the houses, and as a backup, as a fallback. So if, for example, for some reason you couldn't hold these elections because you'd still have very large elections, even if you broke it up. But in case something went wrong, in case it was a margin of error issue or something like this, you could put heredity there as a sort of a backstop, as a way of ensuring that if all else fails, there at least will be a successor. There'll be somebody that clearly in law, where as a matter of law, you can easily prove this is the valid successor. So if it ever got to a court, the only thing the court would have to determine is not the winner of the election, but simply that the election is non-deterministic. And that would only be if it ever got to court. So like in the Bush-Gore situation, rather than the Supreme Court deciding who got elected, they would simply say, well, it's indeterminate, the margin of error is too large, or it's too questionable, so therefore we default to the backstop, the constitutional backstop. And that eliminates a massive problem of constitutional crises in a global scenario, which is different than any national situation, because these kinds of problems will probably be more frequent and they'll be harder to address. And so even with a scheme that the General Federalists came up with for providing equal suffrage, it still is vulnerable in ways that a national system would not be. So that's why that was added. And it's still being discussed, but that's where I think the discussion has ended now. So I'm kind of paraphrasing what's said here, because even this is a little bit out of date. It goes on to talk about the only absolutely deterministic way as a matter of rule of law would be to just fall back to heredity. But that's a difficult proposition, obviously, and it creates philosophical problems as well for corruption, usurpation, and all this stuff. So the hybrid scheme was developed, and it says that A is still representative and B was highly amenable to public annulment or revocation. of that power if the public desires. So while such a hybrid scheme is acceptable for any governing body that actually exercises political power, and that would be the houses, it cannot be acceptable for any public body whose role is to execute the public's right to delegate and annul power, a different kind of power, which is the Senate. And this is an important distinction. This means that the Senate is the toughest one of all to solve, as its members cannot be chosen on the basis of heredity. You can't fall back to it, but actually it is easier than it may appear on the surface. And there's one important reason. Because the Senate is fundamentally different than the houses, and it's that difference that's going to make it a little bit easier with the Senate to solve the problem. We'll see what that's about in a minute. So we provide a solution to this infra in what follows when we discuss the legal character of general federalism, which combines this sort of backstop I'm talking about with a representative equal suffrage, a scheme for doing the equal suffrage where you don't have to have an entire global election all at the same time. And we'll get to that in the next section. That'll be fully explained. As an aside to this discussion, I'd point out that some have projected that the world is not moving toward consolidation or centralization of government, but that it is rather more likely to decentralize. The argument is that the nation state is becoming more irrelevant because it is becoming more dysfunctional. This line of thinking I found very interesting because it is consistent with what we are discussing here in as much as it provides a glimpse into what might happen when large, powerful, neoliberal, Western democratic nation states do in fact fail. One mode of failure is total dysfunction, as we saw in the section discussing the statistics on democracies. At some critical stage, the dysfunction would be so bad that the neoliberal nation state would be unable to enforce its own tax laws, and this would be the final nail in the coffin. In such a scenario, we can imagine a nation state simply lacking the political willpower and being generally too dysfunctional to respond to any city or subsidiary government that simply chooses to ignore the nation state laws. Is there evidence for this trend? Yes, and it is considerable. Just here in the United States, both state and metropolitan governments have begun bucking and ignoring federal laws, a practice that has increased considerably in frequency and severity over the last 20 years. In California especially, both metropolitan and state governments are in direct defiance of federal law or simply seem thoroughly insouciant about it in some cases. Were the failure to proceed in this manner, it would still be, in the long run, a good thing because the necessity of global rule of law placed on society due to technological change isn't going to go away. Once the nation state becomes irrelevant and disappears, it won't be long before the remaining subsidiary governments, possibly including city-states, would have to form some kind of larger federation. This would be inoculating the world of the disease of neoliberal Western pseudo-democracy by killing the host. It's an interesting idea. Once upon a time, one could make pretty reliable projections based on an understanding of just human nature alone. However, and again due to technological change, the conditions and circumstances in which human beings now live are so dramatically different and changing so fast that this old method doesn't work nearly as well. But I wouldn't be surprised if this projection more or less turns out to be our future. So, who knows whether or not that would really come true. That's just what some people think. But if it does, it would actually probably ironically work to the advantage of general federalism, or at least to some set of alternative ideas that might be better than this neoliberal democracy scheme going on right now. The ninth reason why new ideas are needed is that rule of law is, and we're now going to get deeper into this, rule of law is the great public myth of Western neoliberal democracy, and genuine rule of law is desperately needed for a global scheme. So, again, and this is going to get bulletized, so this one reason is going to have several things under it. Again, that theme of, the problems at the nation-state level are only amplified at the global level, and that's sort of the point here is that, even if you could get away with a lack of rule of law in the United States, for example, or any of these Western democracies, at the global level, it's a much bigger problem. So rule of law is the great public myth of Western neoliberal democracy, and genuine rule of law is desperately needed for a global scheme. We don't have it right now. So more illustrations and this is not so much examples put here to prove a point. It's more to help illuminate and illustrate the point being made. So here's one. Attorneys in the United States routinely gather privately and discuss cases. then decide on a, quote, deal they will present to the judge, making the hearing itself a show trial. While this is not supposed to happen, because the judge and attorneys will know the identity of each other, this becomes possible, and back to human nature, it demonstrates it is inevitable. This constitutes an end run around rule of law. General federalism ends this practice by invoking double-blind standards, something never proposed before. Failure to institute double-blind standards is an act of omission in creating moral hazards, and this issue is structural. It says, note that this issue is structural. So, simply applying, double-blind standards is a little bit more involved than that, because, there are a lot of reasons why that wouldn't work if it was not done right. But just prefiguring where we're going here. Just a few years ago, the United States experienced what became known as the mortgage crisis. And here's what really happened, in a simplified explanation. Banks divided their mortgages into groups based on risk. For example, those most likely to default might be in Group 1. Those least likely to default might be placed in the top group, say 10. And the risk of default for each group would then increase from 1 to 10. Then the investment gurus created an investment instrument which was itself composed of several other instruments. Rule of law requires that when you create an investment vehicle like this, you must report the default risk so that credit rating agencies can give the instrument a proper and accurate risk rating. So a legal entity called MERS, which I think it was pronounced MERS, was created to buy the deeds for all the mortgages the banks carry, including all the deeds of risk levels 1 through 10 in our illustration. MERS then violated rule of law by severing the chain of ownership between the deed and the homeowner and instead retitling it in the name of a third-party investment firm. But the clever fraud here was that the reconnecting of the deed back to its rightful owner was not done before the investment instrument was sold to an investor. Rather, they placed all the deeds in what are called tranches, created by the investment firms, basically a bunch of buckets in which to place and categorize the deeds by risk, in our illustration being a total of 10. Normally, the 10th tranche would be the lowest risk bucket and would have the highest credit rating, thus making its market value higher than the higher risk buckets. But when they put the deeds into the buckets, they just dumped all of them in, by illustration, bucket 10, and left all the others empty. So they just took them all and put them in bucket 10, when they should have been divided between all the buckets based on their risk. This put 10 buckets worth of instruments in a single highest valued bucket or tranche. Of course, the rating agencies rated all of them with their highest rating, AAA. Now they could begin selling these deeds, which by this time were converted into investment instruments whose value was backed by the deeds at a premium price. But that also meant they could sell very high-risk deeds at a premium price also. And here's the trick. Only once a mortgage actually defaulted did they then move the deed from tranche 10 back to tranche 9 or some other lower bucket, whatever the right bucket was. This circumvented the very meaning of speculation and risk, as they were not operating with risk, as they were purporting to do, but were acting out of virtual certainty. Thus, once a mortgage defaulted, it was quickly placed into a riskier tranche, and the ownership trail of the deed was, quote, reconnected by robo-signers, the people who signed deeds in order to transfer them, which done in that way was illegal anyway, back to the actual investment vehicle that got moved to the riskier tranche. This is blatant fraud and was never resolved by any legal authority. It was a multi-trillion-dollar theft that was never prosecuted, nor were the actions rule of law required to remedy this problem undertaken. It was a blatant violation of rule of law. This event in particular shows how deeply corporate interest can and have influenced government to the point of suborning rule of law. The entire affair involved approximately 48 million home mortgages. Western neoliberal, quote, democracy has clearly demonstrated an inability to prevent suborning rule of law by the oligarchy, and any global governance scheme will have to have a mechanism that reliably prevents this. And the next sort of illustration of the point, for this reason, judges in the United States are an officer de jure, which is interpreted to mean that their orders can violate the law. A friend at the ACLU told me this, and I've seen it myself. So, being a little facetious, but I mean, typically it is interpreted to mean they can just violate the law. Further, instead of using the principles of equity and law as they are supposed to, they take it to mean they can rule anything consistent with their personal opinion. This is not what equity in law means. Thus, rule of law is subverted. General federalism provides remedy for this and requires judges to state their logic and reasons in every ruling. Giving absurdly corrupting powers to judges is an act of commission and creating moral hazards, and notice that that is structural. And we'll talk more about those absurdly corrupting powers, but one of them has to do with something called immunity, and that's not an easy problem to solve either. And we'll talk about how general federalism tries to solve that problem. Another point, another illustration of this point is that multilateralism exercised by numerous countries means that unelected officials are making decisions that affect their constituents in ways that their own fundamental laws intended to be made through legislation. This is not only a blatant subversion of rule of law, but is a complete suspension of it, another structural issue. And in the United States, the science of public relations is so honed that any candidate with sufficient funds can win an election, and the very fact that voters hear so little of other candidates makes their efficacy in that office appear inadequate to the voter in the first place. When two candidates spend roughly equal amounts of money on a campaign, the result is a razor-thin election, not surprisingly. If one follows the campaign money, it is clear that money, at least in the last 30 years, is what wins elections. Consequently, the faction of oligarchy now controls all the elections, and thus elections are de facto no longer of equal suffrage and are rigged. As equal suffrage is a requirement made in the U.S. Constitution, this is a violation of rule of law. Constitutionally permitting the private funding of campaigns is an act of omission in creating moral hazards, another structural issue. It would, under any other circumstances, be a laughable fact that bribery and corruption are generally understood only in certain contexts, even though their definition applies in contexts the general public, for some reason, seems to conveniently overlook. So it's so obvious in Washington that it's going on that it would be funny in any other context that people don't recognize it for that. In other words, bribery and corruption goes on openly and blatantly on K Street, and the public never seems to notice it. What we're referring to is the idea of special interest, government lobbying. Of course, this is blatant bribery and corruption, but the way in which those terms have been understood has been twisted and perverted to make it appear that only someone who is not a reputable politician could do something like that. Thus, the entire federal government of the United States is thoroughly corrupt, as they take favors or, quote, emoluments from factions, campaign money, in exchange for favorable consideration in Congress of the faction's perspective or agenda. It is blatantly obvious and is a wholesale rejection of rule of law. Yet the United States lectures the world about rule of law. It is astounding. Constitutionally permitting the private funding of campaigns is an act of omission in creating moral hazards, another structural issue. Going back to the Patriot Act again, the United States now can incarcerate anyone without a trial indefinitely. This is not ideological hyperbole, but as I found in my research, literally correct. This is another wholesale suspension of rule of law. This is a matter of ingrained public policy. And this goes back to those overly broad laws with overly broad definitions and consequences. Curiously, what's funny about the Patriot Act, sadly really, is that these powers have actually existed for a long time. It's just most Americans don't know about it. The system is a very clever system. It's very deceptive. And we're going to read about that in a minute, what those powers are. But the same kinds of things you can do with the Patriot Act, almost all of it, has already existed. So anyway, like for example, killing someone for soliciting prostitution would actually be permissible under the Patriot Act, the way it's being interpreted. So, because soliciting for prostitution is terrorism, basically. I mean, they're using it that way. And in terms of consequences, you can be murdered with no judicial process. So, you could basically just kill anyone soliciting prostitution in the United States, which would normally be maybe, 24 hours in jail, if that. Theoretically, in principle, you could do that the way it's being interpreted. So federal judges in the United States routinely, to the point of being almost a certain guaranteed fact, dismiss cases bearing heavily on matters of the United States Constitution simply because it is policy to not hear such cases. This policy, yes, courts also issue policies, are standing rules throughout the courts that other courts are obliged to obey. This is not to be confused with precedent or case law, but is an explicit policy set by senior courts. So this policy must be followed by all courts. For example, if someone's 14th Amendment rights are blatantly violated, say the custody of their natural child is completely revoked without service of process or a hearing beforehand, indeed, even without their knowledge at all. In an open and shut case for which even the opposing party agrees is true, and if it involves subject matter such as domestic relations, which it must, the courts will almost certainly dismiss it, even though they are required to hear it because it hinges on a clear federal matter. The Supreme Court has set case law, which is overridden by this policy, by the way, that if a hearing is held within 30 days after the revocation, that it is not a violation of the 14th Amendment. But I am personally aware of numerous cases where a hearing was not held for many months afterward. And we're bringing up this example because it parallels the one of the Saudi American and American woman, Saudi American man and American woman that married, and how he was able to avoid rule of law, the consequences of rule of law. In the same way here, here's yet another way of avoiding it. So, when a state fails to perfect any of the valid methods of service of process, whether by direct service through a law enforcement officer, valid process server, or by a waiver procedure, and revokes a fundamental liberty right, such as one's access to their natural child, this is cause for a hearing by a jury in federal court. Period. The examples are endless, but even affecting Jesse Ventura when he tried to obtain a federal jury in a politicized matter having to do with U.S. airport security practices. Federal courts have turned the art of finding ways to dismiss cases well before a jury can hear them into a masterpiece, displaying an impressive level of sophistication and effect. It is obvious from the sheer volume of cases whose matters are highly politicized and the manner in which they are routinely dismissed in favor of the more powerful political position at that time and place, that corruption is occurring in that communication with the judges outside court and without the other party, ex parte, is occurring. Speaking of volume, please also note that courts have since their earliest days steadfastly refused the collection of non-identifying statistical data on the outcome of cases, precisely because it will prove what we are saying here. And we shouldn't be surprised at this, since it is human nature to corrupt power. The only way to stop this is to enforce double-blind standards in all courts, a key innovation made feasible in all its seeming complexity under general federalism. And all of this matters regardless of how much of a technicality we want to think of it as, because these technicalities go to the heart of rule of law. When following rule of law, every technicality is followed, as that is the very essence of what rule of law means. You follow the, quote, rules. But let's not kid ourselves. The things we're talking about here could hardly be called technicalities. These are wholesale revocations of rule of law in which a wealthy, powerful individual or favored individual, a faction, can get any ruling they want. It's a complete disaster and farce. This is why we call neoliberal Western democracy a lie. The constitutional illusion of some form of jury representation in the appellate courts, lack of double-blind standards, and a lack of requiring scientific rigor for probative force are all acts of omission in creating moral hazards and is a structural issue. And this part about lacking scientific rigor for probative force, what that means is that if you try to submit some evidence, like you're asking some questions of someone on the witness stand, and you're trying to augment your inference. So you're trying to infer something, and you're trying to strengthen that inference. You can't do it with something that, probably, can't really be substantiated. It can't really be shown to be something that would truly augment that inference. And that's called probative force, the degree to which you can plausibly do that in any given case. It's called the probative force of the inference. So what this is saying is that, hey, what a novel idea. Let's introduce scientific rigor into probative force. That would eliminate a lot of problems too, because this is rampant, and it makes the courts look like a banana republic court. When you hear people up there asking questions on the witness stand, for example, making inferences about socially unacceptable things or derogatory things that make the witness look bad, when in fact there is no actual probative connection between them. It's just a perception. It's just something that makes people maybe look bad, but has nothing to do with actual reality, and that's a problem. It undermines the rule of law. So anyway, courts in the United States have the power to issue two flavors of something called contempt of the court, and this is where this ties back to the Patriot Act and what I was saying earlier about how many of these powers have already existed and people just don't know it. So courts in the United States have the power to issue two flavors of something called contempt of the court. The two flavors are criminal and civil. Here, yet another backdoor to circumvent rule of law is structurally built in, because should a judge issue a contempt order, either civil or criminal, a person named therein to be arrested can be arrested without any stated cause, without any reading of rights, without any reading of the court order itself, and can thence be placed in jail until the person pays whatever fines the judge wishes to demand in the contempt order. Notice that several rules of law we generally take for granted are being violated here. This is a tool of choice when dealing with any, quote, normal person who has a slam dunk legal case against an oligarch or other favored person and who just won't go away. By assessing attorney's fees, expenses, or other required remediation costs that are, of course, all trumped up, a judge can order the paying of massive fees that no, quote, normal individual could possibly pay. This allows the judge to jail this person for many, many months. I cannot speak for every state of the United States, but I can tell you that in the state of Georgia, this is more than just routine. People sit in jails in Georgia for several months on account of an inability to pay a fine set by a judge. And they obviously cannot pay it if they're sitting in jail because, for one thing, they would pay it in order to get out. So if they could pay it, they would have paid it in order just to get out. Secondly, they cannot do anything in jail as far as paying anything or even coordinating the payment of fines because communication is so highly restrictive in jail, very restrictive. And third, they cannot pay themselves because that's the rule they impose. So someone else has to do it in their stead. So even paying the fines, is onerous and difficult, very hard to do, even if you had the money. And we're not talking about bail here. Speaking of which, these cases offer no bail option at all. Again, the purpose of this provision, like the officer de jure nonsense, is to give judges the power to circumvent rule of law when oligarchy or privilege is in a bad way and a case is heavily stacked against them. General Federalism eliminates this moral hazard by requiring that no one can be jailed on the basis of any debt or fee by itself. The granting of legal powers that are excessive and resilient to accountability is an act of commission in creating moral hazards and another structural issue. So those who have talked a lot about the culture and the background of people like James Madison and Alexander Hamilton and all these people in that day and age and their concerns about it are valid because their belief systems and the way they looked at the world it affected all of this. This is a deliberate system. It was created this way. It's based on deception. There are built-in mechanisms deliberately put in place in Western neoliberal law systems, legal systems, that have become normative. They're accepted now. That really were put there for class reasons. They were really put there for privilege. In such a way that the public would not be able to easily see that that's happening. The public would think that really would not really have an explanation for why they got wacky rulings from the courts. But it was so well obscured from them that they could attribute some of the reason to it. This is all deliberate and part of that design. So yes, their culture and their background did play into how they look at all of this. But a lot of that was not so much what they wrote in the Constitution. It was just what was normative. Normative meaning what was the standard at that time. And by adopting the standards of Western law at that time, it got grandfathered into the United States, essentially. So absolute immunity of judges has been grossly abused. So here's where we talk about that. In many cases by state legislatures themselves. In the state of Georgia, the legislature there pulled a clever trick to circumvent rule of law. They passed a law that allowed courts to hold hearings in which a person's rights were revoked or disfurnished without telling that party that a hearing was being held, an ex parte ruling. But unlike the Supreme Court's ruling said nothing about how long one could do this without a hearing with the affected party present. Now, we're talking about the limited case of what are called fundamental rights that the Supreme Court has talked at length about. And one of those is the access to your natural child. That was one of them. Not a whole lot of rights like that. But this meant that if the judge issued a ruling and did not hold a hearing within 30 days, he or she was in violation of the 14th Amendment. So it's violating fundamental law. It's violating the Constitution. But because of his or her absolute immunity, and it's absolute, as the Supreme Court has sternly ruled in case law, you can do nothing about it. As we can see as we enumerate all these, quote, secret tricks, and they are, it is clear that if the United States government wanted to go down the road of despotism, it is already well equipped for it. General Federalism places limits on absolute immunity of judges. It does have a good reason for existence, but limitations can be placed that do not undermine its purpose. The granting of legal powers that are excessive and resilient to accountability is an act of commission in creating moral hazards and another structural issue. Structural and normative, and however you want to look at it. So the way general federalism addresses this is through the introduction of another controversial concept, but with a view towards addressing the concerns about that kind of instrument. So the problem is that you need absolute immunity for some officials. You just do, because we can think of the example of someone like La Cosa Nostra or some organized crime figure having to go to court, and the state trying to prosecute them. And because they have all this money, they just hire all these attorneys, and they just try to harass all the judges with lawsuits. And it may be that because judges are constrained by rule of law, presumably, they might actually have to hear those cases. They can't just throw them out, and they might be able to sway a jury. So that could completely undermine the system. There has to be some way to control that and place filters on that. So general federalism solves that by the use of tribunals that are heavily restricted in the way that they can be called. So someone has to make a request, a petition. An individual can make a petition through their state's executive authority. And the executive authority is a political entity. They're not bound by legal systems and all this stuff and all these rules. So if it's clear to them that this is specious or there's something going on, they can easily just drop it there. But if the person is persistent and has a righteous cause and they lobby their governor, likely it would get passed on to the House of the Fiduciary, which is the federal level. And the House of the Fiduciary would consider it. And they can be lobbied. And they are also a political entity, because to keep in mind the way the Constitution is written, the Supreme Court is a body created by the House of the Fiduciary. The House of the Fiduciary is a political institution. The Supreme Court is independent of most of the government, pretty much. But it gets its support, and it gets a lot, and the House of the Fiduciary does a lot of things related to justice, such as the tribunal thing, on behalf of the American people. So they are, another filter. And again, it also works the other way, where if you've got a system that's self-protective, because that's the obvious concern people have had about it, is that, well, the Supreme Court keeps ruling in support of absolute immunity because, it's self-serving. By having politicians or political figures who are subject to public scrutiny, looking at it, adds a little bit more balance into it. So if they look at the case and they see it's absurd, regardless of the immunity, then it may progress through the system. And finally, there'd be a tribunal, but there's a lot of restrictions on how a tribunal can be put together. The Senate has to approve it and all kinds of stuff. So you can't use it as a weapon and a witch hunt tool, or that's the idea, is to prevent that. But anyway, an example of how absolute immunity has been abused is there was a case many years ago where a judge, I think I mentioned this somewhere, I think it might be mentioned in here somewhere, but at the risk of repeating myself, there was a case a long time ago where a teenage girl, I think she was 15 or 16, was misinformed and not told what was going on. And the mother went to the judge and asked him to sign an order to have her sterilized. He signed the order. And they sterilized her without telling her what they were doing. And so the judge had her sterilized. And the case went through the system, wound through the system years later when she sued and when she couldn't have kids, only finding out years later that she couldn't. And it ended up in the Supreme Court. And the Supreme Court ruled that it was not a violation. It did not meet the criteria for an exception to absolute immunity. So absolute immunity covered him in that case because it was an official act. It was a court order. It's not like he did it personally in his own home. It wasn't a private, personal thing going on. It was an official act. And as long as it's an official act, absolute immunity is almost impossible to overcome. And even though you can make a legal argument for overcoming it in case law, they'll still dismiss it. So that's what that's all about. So another point, another illustration of this one reason we're still in, is that what we see here, as we do in virtually every case in the United States, is a unique strategy for violating rule of law. In other words, especially non-Western countries, violations of rule of law are more overt and open, but in the West, trickery and deceit is the name of the game. This unique strategy, so thoroughly perfected in the United States, is to deliberately create moral hazards for actors in various roles, then use that to circumvent rule of law. This is the normative culture and values systems solution to the problem of governance. Is really what this is. Either by blackmail or simply by relying on their human nature. In creating the moral hazard, one does not necessarily have to violate rule of law themselves. This gives the appearance of a working system of rule of law, while the true violation occurs behind closed doors in ways not easily observed by the public. It is deceitful and dishonest. Of all the characteristics of general federalism, this disdain for deceit probably differentiates it from just about every other global governance movement more than any other single characteristic. That might be more the author's opinion than mine, but anyway, this is a structural issue too. So what I'm sort of stressing here again is that all of this deception and the way the system is rigged to violate rule of law has an historical and normative background. It's coming from a history of this, and it's class-based. The upper classes have always been using that kind of tool, the deception thing. So it isn't surprising that we see this, and that the public doesn't really know much about this. It's not that well known. And we can see why. I mean, as we go through this stuff and we extract it from this these technical areas, it's obvious. It's easy to see why. It's not common knowledge. It's subtle, and it's embedded deeply into the system, into the normative aspects of that system. So very hard to pick out. Another illustration here is that slavery is illegal in the United States by constitutional amendment. An example of how slavery works might go like this. If I decide to purchase 100 slaves from some distant location overseas at a price of X per head, there's a reason why I'm doing this. And I'm sort of playing the role here. I'm doing this because I know that despite what I spent on the slaves, owning them and putting them to work on my plantation will generate far more money than what I spent purchasing them. Of course, that calculus involves some speculation on my part. First, I'm speculating that only a small percentage of the slaves I purchase will fail to be productive. Some may die, some may not be able to work because of health, etc. And I know that some will fall into this category. But if the price per head X is right, and the gains I know I'll get by using even just the remaining healthy slaves is high enough, I know I will profit. So I am speculating on the future economic performance of a group of 100 human beings. I'll say that again. So I am speculating on the future performance, a future economic performance of a group of 100 human beings. I cannot know for sure which ones will be productive and which ones will not by name. But all I need to know is what is the likely percentage of productive individuals in that larger group. So the future economic performance of any one of the named slaves is speculative and doesn't really matter to me as the slave owner. But it's still speculation based is the point. And if we switch lenses now, we can see that the exact same definition exists with unsecured credit. In this scheme, I give a large sum of money, like I did when I bought slaves, to a purveyor of credit. And this purveyor loans this money out to several people, say 100 people. But in doing so, they sign an agreement with these people that requires them to pay back my money, plus some amount of interest. I know that if the interest is high enough, and if I can have a rough idea of how many of those 100 will fail to be productive, and thus fail to repay me, I can adjust that interest rate to ensure that I profit from all the other debtors that repay me with interest. In this example, I am speculating on the future economic performance of a group of 100 human beings. However, by making it, quote, voluntary, a questionable claim we'll make for the sake of discussion, and by obfuscating it in the world of abstract finance, I am concealing the fact that I have just circumvented rule of law by making an illegal activity legal, even though the law never changed. For if the gravamen for making slavery illegal is not that it constitutes speculation on the future economic performance of human beings, how else would you define it in a way that would capture all forms of slavery known at that time? Clearly, this speculation on human performance is the basis of slavery itself. It's the best operational definition. So slavery has been reintroduced and rule of law violated again, and another structural issue. And again, we see the normative pattern, this grossly overlooked aspect of managing the social contract. We'll talk about this more later, but there's just the massive historical baggage that has been brought forward into the present from the past. having to do with class and normative assumptions that are poorly studied. Most people that study the social contract and global rule of law don't even ask these questions. They don't even look at all these normative aspects. But it's these normative aspects that are the cancer, because they're giving rise to the moral hazards we're talking about, and the subordinating of rule of law. So very important to realize that as we go through this, to pick out and observe and see the normative aspect of so much of this. So another illustration. In the United States, the right to be protected from unreasonable search and seizure is the law of the land. However, as noted in previous examples, if you take such a case to the federal courts, it will almost certainly be dismissed. In cases running rampant across the United States are frauds, such as storming into private residences, where a warrant, also by law of the land, is required before entry. Simply having the warrant, or the warrant being in existence at the time of intrusion, is a mockery of the meaning of rule of law. Without allowing the residents an opportunity to validate the authenticity of the action, the intruders are trespassing, plain and simple. And here's why. But the rule of law protecting one from unreasonable invasions, in which the resident has no knowledge of the required oath or affirmation, the warrant, is circumvented by existing practice and the federal court's refusal to hear such cases. It's this protection against unreasonable searches that requires, in any rational analysis of this, would require people to have some way of knowing that this is an authentic, authorized, lawful act before they have to give up such a basic right to their home. It's just ridiculous. So anyway, it is true that occasionally federal courts will hear cases like this, but only when it is brought by oligarchy or its agents, the privileged, and only to placate growing public anger and sentiment. The vast majority of cases of this nature are dismissed out of hand. General federalism puts an end to this moral hazard by simply denying the right to enter any place serving as a private abode at all. There are exceptions, but that is the gist of it. Another structural issue. So in the case where there is a active pursuit of a felon, where someone's held against their will or someone's life is in danger, they can enter a home, but that's more of an exigent situation. Other than that, they can't enter a private abode or draw information out of it or anything like that. It's just completely forbidden under this general federalist view. If any agent of government notifies or informs a citizen that a given set of rules of law exist when they do not, or states that a given set of rules of law that do exist do not, or if they simply misrepresent existing rules of law, then under general federalism, the agent would be considered to be violating rule of law. This is because by dint of the agent's authority as a lawful delegate of government, they implicitly or explicitly compel the citizen to behavior outside the actual rules of law. And if you can cause someone to violate the law, you are violating the law. Sadly, this happens on a routine basis every day in the United States, usually being perpetrated by law enforcement. Notice that this is structural. Advertising in the United States has clearly crossed the line into blatant fraud, and virtually every American can easily see that fact. For example, when a software company collects your financial information to sign up for software as a service, then tricks the unwitting computer user to respond to an advertisement for a different product or service in which it isn't clear to the buyer, which is what matters, that it is in fact an ad or that they've even consented to a purchase, and the advertiser charges them for that purchase using the financial information already collected, it is clear and blatant fraud. Once again, because the courts are structured with so many, quote, ejection seats, to get them out of cases like this, that normative thing again, they can either rule in favor of oligarchy and privilege or just dismiss the case entirely. Seldom will one ever get to an actual jury. General federalism includes a specific constitutional provision to stop this practice. The constitutional illusion of principles of justice and economics is an act of omission in creating moral hazards and is another structural issue. I mentioned oligarchy, but really what we're talking about is faction and those that benefit from faction. Is probably a better way to say it. It doesn't necessarily have to be oligarchy. There are those that are privileged who can benefit from oligarchy as well, simply because they're caught up in whatever it is that oligarchy is trying to achieve. They can simply, as a byproduct of what the oligarchy is doing, be privileged. So that happens too. So one of the areas most rife with corruption in the courts of the United States is the area of domestic relations. Here, the federal government pays states a proportionate amount of money for the amount of child support they order. In other words, the states are getting kickbacks from the federal government to order child support. The problem, however, is that this compels judges, the same people making determinations of child custody, to give almost all custody rights to just one parent, not divided equally. And the overwhelming consensus is in the psychological profession is that joint, down-the-middle custody of children is by far in their better interest, which is what almost all courts claim that they're trying to resolve. And this is hilarious. People in the legal profession love to discount the value of psychology. And they'll say, well, that may be the consensus, but, we don't really agree with that because we don't really agree with psychologists. We think they're crazy. But what's funny about that is that, okay, so does this then mean that the judge is more competent to make a decision like that than the psychologist? I think not. Whatever you think of psychologists, I would say that a judge's competency in that subject area is less. So, judges simply revoke almost all custody from whichever parent the constituent community will least be in uproar about. And this is critical. This is why you see differences in these kinds of rulings in different parts of the United States, at least. And the same thing in different countries. Neoliberal countries, you see the same pattern. They're ruling based on whichever parent the constituent community will least be in uproar about. So if it's a culture that values sole custody for mothers, the mothers will get it all the time. But if it's one that values sole custody for fathers, which happens sometimes, in many cases, the father will get it. So that's kind of funny. It just shows the sort of the hypocrisy of democracy. But anyway, so let's see. So the judges simply revoke almost all custody for whichever parent the constituent community will least be in uproar about. And there's the final cause of this moral hazard. Judges in most districts and circuits are elected directly by the residents of that area. But the same problem of special interest comes into play, and judges are put in office by those with the deepest campaign pockets, the oligarchy and the privileged. So, kind of exactly what I said. It's going to be who makes the least uproar, because that's who they have to kowtow to. And that is why judges always use these tricks and, quote, escape hatches to circumvent rule of law and please their masters. General Federalism forbids this practice by having judges nominated by equal suffrage and a candidate then appointed from that selection. Hybrid of the two systems. The failures to protect individual liberties are acts of both commission and omission in creating moral hazards, another structural issue. And both state and federal statute in the United States is a bloated tome of years of legislation piled on top of itself. The inevitable result of this is that eventually blatant contradictions and internal inconsistencies in law appear. It is a verifiable fact that about 25,000 new laws are passed in the United States every year. It's just in the United States. It is truly astonishing to find that in most bodies of statute, to include United States Code, for every law found, one can find another law somewhere else in that corpus that blatantly contradicts it. This again creates a moral hazard by allowing judges to simply pick whichever law they prefer in any given case and apply it, even if they are bothering to read the law in the first place. Usually they just rule on their personal opinion. Yeah, because when they do quote law, they're using it to justify their opinion. So it's really just a silly game of going to try to find a law that will back up their personal opinion, so that it makes it look legitimate. And so they don't really mind the fact that there are contradictory laws in the books, because that helps them as the system works today. So this is another wholesale corruption of rule of law. General Federalism addresses this by requiring courts to identify contradictory, internally inconsistent, and or redundant law, declare all of them unconstitutional, or codified together as such, and only then reach a ruling in the case presenting. And they must do this in every case heard, virtually guaranteeing that contradictory law doesn't live long in statute. To be clear, this doesn't mean they have to go through all of the code every time they do a ruling. It just means that if they're going to quote law, they're going to have to do some due diligence and just make sure that they've looked at all these similar laws to make sure there aren't any contradictions. That's all that's saying. And that's LexisNexis, that's very quick. That's not a problem. It's easy to do. Failure to constitutionally require courts to rule on such inconsistencies in every hearing held is an act of omission in creating moral hazards and a structural issue. All of these are structural, except that Patriot Act policy, which ironically manages to escape that, at least in and of itself, but it's the structural issues that gave rise to it. The United States Congress has passed laws over the years requiring that, in certain politically sensitive cases, original jurisdiction in federal courts shall not begin where it is supposed to, and always has before, with the lowest federal court, the district court, but rather shall first be heard in federal circuit courts. where no jury is present. This is what happened in the example given by Jesse Ventura, or given of Jesse Ventura. General federalism ends this practice by first explicitly denying the government any right to place barriers to anyone seeking to have their case heard by jury, and second, by constitutionally framing the courts such that all courts, including appellate courts, have juries. In Western law, an appellate court is only supposed to evaluate the question of whether or not the lower court erred in its ruling. It is a decidedly procedural analysis and is the reason why juries were not required. Appellate courts do not try facts, which speaks directly to merit. They thus don't really try a case on its merits either. They are simply making a determination of whether or not the lower court made some procedural mistake. Under general federalism, the role of the appellate courts is altered because of this moral hazard we've now historically learned about. Under general federalism, the role of the appellate courts is both to be an arbiter of procedure as well as a limited trier of fact. However, the restriction of trying fact is that the appellate courts are not empowered to hear or collect new facts unless a lower procedural error prevented its entry there. Thus, under general federalism, appellate courts hear matters of procedure without a jury, then under limited conditions hear matters of the merits of that same case with a jury, and the jury's decision is final. So the judge has to, there's this thing called jury instructions. They publish these for federal courts and state courts. And they're recommended jury questions for every type of case you might hear. What would happen here in the appellate situation is they would go ahead and make a decision about the procedural matters. And then in the instructions to the jury, they would be instructed based on what the court found as far as regards procedural matters. So if there was a procedural violation or something like that, then the law may require that it be remanded back to the original court or something like this, and the jury would have to follow that. So that would be included in the jury instructions. But once that had been resolved, once the court had looked at the procedural issues, then the court would hear the facts as limited here, as I explained, and the jury's decision would then be final. They would take all of that in and make a decision. The denial of juror involvement on any level in the appellate system is an act of omission in creating moral hazards and also is structural. I think we're going to need to stop here and finish this. We've gone over an hour, so we'll finish this in the next section, next video, which is 4 of 8. So for now, this is it, and we will be back shortly with 4 to finish why new ideas are needed. And we'll see you then.